Good afternoon. If I can simply pick up where I left off before the short adjournment, just talking about what's necessary or not for redevelopment. Just to be clear about foundations, because my own friend made another point about, I think he said foundations might be shared, they might be not. If you've got a party wall, which is a shared wall, then the wall will have foundations. Therefore, there must be foundations under the shared wall, and those must be shared foundations. There must be party foundations in the same way that the party wall is a party wall. So there have to be such things under the party wall. As I understood it, my own friend Mr. Bates accepted when he was asked directly by my Lord Justice Miles whether you could draw a line down the middle of the party wall. Would that be fine? And he said, yes, you can draw a line down through the middle of the wall. But if you can do that, you can draw it straight down through the foundations until you hit the subsoil beneath the two buildings. There can't be any distinction. So the foundations are a red herring, in my respectful submission. The next point, which no one has, or we've only had my own friend, there was only one case on independent redevelopment, which was a first instance leasehold valuation tribunal decision of Stamford Hill Mansions, which is it's in the authorities bundle of tab 9. I don't think, I suspect this court probably isn't going to base its decision on an LVT decision from 2007. It probably doesn't need to. The test which was applied in Stamford Hill Mansions was to borrow from another section of the 93 Act, which was the landlord's redevelopment right, which is very similar to the landlord's redevelopment right in the Landlord and Tenant Act of 1954, which is a test of substantial works to a substantial part of the building. I'm paraphrasing. So my position on that is, well, primary position is the Upper Tribunal adopted it. It's a good working test of what redevelopment means in section 72. But it's not necessary to directly borrow from section 23 of the 93 Act, because the FTT, as I've already said, got it right by simply saying all that independent redevelopment means is redeveloped independently of the rest of the building, as in you're developing one building and not the other. And what redevelopment means, since it's not defined in section 72, or indeed in section 3 of the 93 Act or section 117 of the Building Safety Act, it must be a common sense test of works which are sufficiently substantial that the reasonable person on the Clapham omnibus would say, yes, that's a redevelopment. That is the alternative. Either way.
If that's right, that may have implications for the role of this court, because generally speaking, in various parts of the legal system, you see concepts that are not pure concepts of law. They require some judgment to be formed, some evaluation to be exercised, usually by a court or tribunal at first instance.
Yes. And
generally speaking, such questions are decided according to fact, degree, and judgment. And generally speaking, this court, as an appellate court, then does not and cannot interfere with those evaluative exercises or judgments if it's a question of fact and degree. Throughout the legal system, there's sometimes a distinction drawn between what's called a hard-edged question of law, which obviously is for this court on appeal to decide for itself, and other questions. If what you're saying is that whether something constitutes redevelopment is one of those kinds of questions, it's a question of fact and degree, then would it follow that we can't interfere with the judgment of a lower tribunal unless it's not reasonably open to it?
Yes. Well, that's right. And for this purpose, it doesn't matter whether the test is directly borrowed from section 23 or whether it is, as the FTT put it, It just means the common sense meaning of redeveloping a building without redeveloping its neighbour. Whatever the test for redevelopment is, it is inevitably, when applied in practice, it will have to be judicial evaluation. And yes, so the usual test applies. You will only interfere with an evaluation in the same way that you only interfere with discretions, i.e. it has to be, was a factor ignored which should have been taken into account, was a wrong factor taken into account, or was the wrong test applied, or was the outcome outside the spectrum of decisions to which the reasonable tribunal, properly self-directed, could have arrived at. Yes, that the decision as to what, as the decision as to whether a property could be redeveloped in accordance with that test is evaluative. As I've said, the First-Tier Tribunal, my flat submission is First-Tier Tribunal was correct, the Upper Tribunal adopted it, and as I said in my skeleton argument, although I'm still on my feet now after however many minutes, in theory I could have said simply dismiss the appeal for all of the reasons given by the Upper Tribunal, because it is a conspicuously clear, comprehensive and correct in all material respects decision. It could be as simple as that. So I won't go on too long, but that is my fundamental proposition. Just finishing, however, the points I was making before short adjournment, there is the question of, it should be considered as well, you know, what might not satisfy redevelopment. I gave the example of the undivided space which has been artificially divided by stud partitions and so on, where that's probably not going to be capable. The Albion Riverside case, which is in the bundle, which is a complicated building, but on the facts of that particular case, some of the loads from parts of the building were, because of its splendid architectural design, they were spread laterally through lateral structures, through flying buttresses and podium decks and so on. So if you remove part of a structure which is taking lateral load, then you are probably not going to be able to redevelop that part without redeveloping the rest. In that particular case, there was a car park, but the car park was a box, and part of the evidence was that the weight of part of the above ground structure kept the car park box from heaving, because it's on the riverside, so you get hydrostatic pressure from the Thames underneath, which will tend to drive the box up, unless you've got a counterweight of a building on top of it. So again, taking away the part of it may remove that weight, which will then have a knock-on effect. That occurred to me as another example. There will be cases, I would suggest, where no amount of propping or underpinning is going to preserve the rest of the building. And it could be because the structure of the overall thing is just too weak. Old buildings may be very vulnerable. It occurs to me soil conditions. In some places the soil is very friable, in which case it may be that it's just too dangerous, perhaps, to remove a building. It might be on a steeply sloping site, and again you get the same point. So there are all sorts of cases where it may not be possible to satisfy the independent redevelopment test. But in a sense, I would say, although it's a big building and it's in a great location and so on in London, actually 14 Park Crescent is a communal garden terrace. And none of these exceptional circumstances apply, and we know for a fact that it could be redeveloped independently because it was. That is effectively the end of that. Actually, I did come up with another example, which is it might also depend on how buildings were built, because of course we're assuming buildings built at the same time, but you could have a building which is formerly freestanding and then a new building is built off it and you enclose upon it. It might depend which one you're trying to redevelop. If the thing which is built is effectively a lean-to with only 3 new walls, is the new thing, and you want to redevelop that, it might be very easy, because of course it was added to the original building A in the first place. Taking building A away, the original building, without taking away the lean-to, might be much more difficult in practice, It might be possible to cut away the frame to leave a vertical wall, but it might not. So there will be, just in case my learned friend says that on my test there'll be no building which doesn't qualify, actually when you start to think about it, there will still be buildings which can't satisfy this independent redevelopment test. Just not nearly as many as there would be if my learned friend is right, where I would respectfully submit practically no terraced building is ever going to satisfy it, and thus the Act will be emasculated. The question arose on some small points before I then take one or 2 points only into my skeleton. The question of the status of authorities under other acts. Well, clearly authorities, for instance, under the 1993 Act are not binding authorities in respect of the 2002 Act. Evelyn Mansions is an obvious example of it because it was an identical argument to Craft Rule, with no difference at all. So if Craft Rule had been a binding precedent, you couldn't have had Evelyn Mansions. So they're not binding precedents, but they are more, certainly 93 Act cases, and if we ever get a Building Safety Act case under 117, they're more than just relevant, they're going to be highly persuasive because the wording of the three sections, it's not just similar, it's effectively identical, apart from what sometimes they say it instead of part. It meaning part. They are the same formulation. The only real difference is that in section 72 of the Commonhold Act, it says a self-contained building or part of a building with or without a pertinent property, which is an extension. But if you shear that away, the definitions are the same. So what is decided here will be relevant to 93 Act and to any subsequent Building Safety Act case, which I think is one of the reasons why the Upper Tribunal thought that there should be a second appeal, because this is potentially a quite wide implication. So if you decide, as my learned friend would have it, that lots of terraced buildings don't qualify for RTM, you will also conceivably be deciding that they don't qualify for the protections afforded to leaseholders under the Building Safety Act for cladding remediation, for example. And they won't be able to get a remediation order because the same test has been applied by Parliament in all these different contexts.
I can understand that submission, but do you also submit that the 1967 Act case law has relevance in this context? We've seen
one respect.
In one respect, right?
Yes. The 1967 Act grandfather provision as a grandparent provision is different. If I can briefly go to it. So it's on page 646 of the authorities bundle. Which is section 2. The part of section 2 which is relevant because it is the parent of the vertical division is subsection 2.1b, which my learned friend didn't refer to. And so having said that a house is a house reasonably so called, it says where a building is divided vertically, the building as a whole is not a house, although any of the units into which it is divided may be, i.e. any of the units into which it is divided vertically. And a unit into which a house is divided vertically is a vertical division. So I respectfully submit that if a 67 Act case is considering what is meant by vertically divided, then that is very similar to the meaning of a vertical division under the 93 Act or the 2002 Act or the Building Safety Act.
And is there any relevant authority on that?
Authority on which I would rely, or authority which supports the proposition I've just stated?
No, authority that you rely on.
Yes. So the reason I put this in, really, is simply for the Birchley case.
Ah, right.
Which I was going to come to, but perhaps this is as...
Whenever suits your order.
Okay, well, I'll come back to Birchley in 5 minutes, perhaps. But that was the reason for putting that in. I mean,
I see.
I don't actually agree with learned friend, that we've in effect got lots of 67 Act cases in the bundle. I think we have 2. And I'm not sure that I put the second one in there. But anyway, so that was the only reason for relying on the 67 Act.
Yeah.
What
I think is common ground, is this right? Is there is no materiality test in the present context, whereas there is in that context.
Yes. So for whatever reason, under the 67 Act, the Parliament was prepared to consider that a house might have a part which projects into another property, but for the purposes of the 93 Act and subsequent statutes, it has to be an absolutely vertical division, subject to de minimis.
Thank you.
So we don't have it in the bundle, but there is a actually we do have Malekshad and Howard de Walden at tab 6, and the point there was that the basement of the main house on Harley Street went under the mews, and that projecting piece of basement under the rear mews is a deviation from the vertical plane of division, because effectively the back of the house does that. But that would be non-material, so it didn't disqualify the main house on Harley Street. If the Harley Street house had been flats and it was a collective claim, then it would have disqualified it unless the court had been convinced it was truly de minimis, which it possibly wouldn't be. So there's that little difference, yes. But I would say you only get to that once you've considered what the vertically dividing feature is. Then a point came up this morning about the RTM company's functions, which I've addressed under section 96, and the question came up about insurance and rebuilding. And I don't think I'm quite on the same page as my learned friend here. So it is right that the RTM company would have the function of placing insurance, although the landlord has a right to keep doing it themselves at their own cost. But primarily it would be the RTM co would do it. But of course, that's placing the insurance. So who are the insured under the insurance which is placed? Well, it would include the RTM co, because the RTM co's liabilities under the Act would count as a sufficient insurable interest on their own, but the primary insured party would be the landlord, and no doubt the tenants as well for their flats. So the landlord would have their interest noted on the insurance. My learned friend, well, the question is, let's assume there's a total loss catastrophe and the building is burnt down, the insurance pays out, and there's a fund of money for rebuild. I would not accept that the RTM co would be the rebuilding party, because the RTM co's management function is for repair, and completely replacing the building with insurance money after a catastrophic loss, I would suggest, is almost certainly going to be held to go beyond the scope of the covenant to repair. It's probably dealt with by a different covenant in the lease, which will be to pay out insurance money. So I would expect, perhaps it's a long way of getting back to my Lord Justice Miles' proposition that the person who would actually do the rebuilding is the landlord. So I don't think the insurance point...
Possibly in conjunction with the tenants. Do they, because just trying to work that through.
They would also have an insurable interest.
But qua tenants rather than through the RTM, you would say?
Yes, because their insured interest would derive from the fact that they have the leasehold estate in their flats. And the landlord has the freehold estate in the common parts and the structure. And if there's a head lessee, they have the leasehold estate in the common parts and the structure and so on, and a reversionary estate on the flats as well. So all of these parties all have an interest. Usually the lease will say whose job it is to pay to rebuild. It will probably say that it's the lease will say that the landlord has to insure and to pay out any insurance money on rebuilding. That's the usual way it is written. The RTM company will take over the function of placing the insurance, but I would respectfully agree with my Lord Justice Miles. It is unlikely that the RTM company would, under section 96, be said to be the person who has the function of carrying out the rebuild. Bearing in mind that, as my learned friend said, under section 97, if the RTM company has the function, then the landlord is excluded from it. So if the RTM company is supposed to rebuild, the landlord can't. It's cut out from this. And that seems rather unlikely and extreme. Whether that interesting debate about how far that goes has any particular relevance to the construction of the Act, I'm not sure.
It's taking a very extreme and perhaps rather unusual circumstance rather than the more obvious question, which is just whether the property can be redeveloped.
Yes. I respectfully submit yes. That is right. And in terms of the construction of the Act, I said before lunch that there was a good summary in Mrs. Justice Foxton's judgment in Palgrave Gardens, but at that point I didn't take your lordships to it. The first page reference I gave you was on page 477 of the bundle. And it's really from the beginning of this Act, it's about the construction of the 93 Act and the general policy, but the same, I would respectfully submit, largely applies to the 2002 Act. We've got the policy set out in Major State. She summarises Lord Justice Millett's general approach to interpretation in paragraph 27, which I've in effect referenced several times by saying is intended to be construed, if possible, to make it effective to confer on tenants those advantages which Parliament must have intended them to enjoy. Which then sets out the slight qualification to that made in Hosebay Day in the Supreme Court. And then at paragraph 30, you have the Cadogan and Panagopoulos quote, which is the basis for saying that considerations of practicality and convenience are important, which will be important to construing in this context what vertical division and capable of being redeveloped independently mean. So that was the first page of quotes. And then at page 488, Mrs. Justice Falk then picks up what was then the most recent general policy statement about the 1993 Act, and again, which can be applied to the 2002 Act, citing Lord Justice Lindblom in LM Holmes, again, just conveniently set out here. And so her first point, or Lord Justice Lindblom's point, was first, the statutory scheme is self-contained and comprehensive, and though complex, ought to be regarded as coherent and complete. Well, that must apply to the 2002 Act. Clear and certain outcome, and then thirdly, Cadogan and McGurk again. So they're just, obviously they're not new statements, but they're conveniently collected in that case. In other words, it occurred to me, having thought back on the summary I gave in my 40 minutes before the short adjournment, that I'd actually pretty much said everything which I was going to say in my skeleton argument, just put it a little bit more shortly. So I've only got one or two points which I would wish to add. So the first point is a further reference. If in paragraph 12 I referred to why the 2002 Act has this particular test in, which is lifted from the 1993 Act, and I referred to some explanatory notes about the dovetailing. If it is important, there's a paragraph in the Fencott case on page 260, which addresses the same point. And it's mea culpa for forgetting, because I was in Fencott. I'd forgotten that I'd gone over the same ground before.
And this again was the Deputy President, is that right?
Fencott was again the Deputy President, yes. So it's at the bottom of page 260. It talks about the particular provisions about RTM companies.
Yes, thank you.
Probably this is the point at which I would now refer to the Birchley case.
Yes.
So the West End and Birchley is in the bundle at page 379. I realised slightly late, and I'm sorry about this, I realised that I'd referred in my skeleton argument to photographs, which actually only appear in the Weekly Law Report version.
Yes.
And I sent them in by email.
Yes.
And they're probably helpful to understand the rather unusual property. I've got some hard copies if it's easier.
I would personally like one, please, if you've got it.
So I've inserted my hard copy where it was. Can you just remind me which tab it is?
17. Yes, I only copied the photographs since I hope that the report itself is the same. I'm not be entirely sure, but hopefully the text of the law report is the same. So if one looks at the first photograph, the property which was being enfranchised is the Mews house, which is nearest to the right-hand end of the page. You can see some whitish garage doors. So it's the end Mews house, and you can see immediately beyond the end Mews house is this enormous looming wall, and at the top of the page is slightly indistinct. It is a huge stone chimney, and then the second of the photographs is looking down, so onto what is the roof of the Mews to the left, and the huge wall of the Grosvenor Gardens property, the rather grand property which fronts onto Grosvenor Gardens, is on the right. So where you can see it from Grosvenor Gardens, it is faced in stone. Where you can't see it, of course, they just used brick, which is why it's brick on the first of the two pictures. And the issue in that case was about whether or not there was a vertical division. And the best way to look at it, and I do suggest this as a sort of salutary warning as to where the landlord's argument in this case can lead, it is to look at the diagram which Mr. Justice Henry Carr incorporated into the judgment at paragraph 13. And this is it's all this point about drawing lines through party walls, because in this case there is a party wall between the Mews house on the left and One Grosvenor Gardens on the right, but obviously it's only a party structure where it is hatched, because that's the height of the Mews house. Above that, the flank wall of number 1 Grosvenor Gardens, the tall building, is facing onto thin air, because party walls are only party structures up to certain levels. So the argument ran that it was fully in the ownership of number 1 Grosvenor Gardens, where it is above the height of the Mews. And because of that, it's not a vertical division, because there's a little dog leg from the vertical within the wall. What I think I called in court the sort of the one brick deviation from the vertical. And we should probably give give credit because the person who drew that, the instructing solicitor, is Mr. Sirota, who is here. So this is his handiwork in drawing this to show us what the problem was. And that there are two ways in which this is addressed in the decision, and I say it's exactly the same point you can get with a vertical division under the 93 Act. The first is to say, well, if there is such a deviation, that's just de minimis. If there's a deviation of the notional line within the party wall. Because of course, and Mr. Justice Henry Carr makes this point, it doesn't involve any of the floor area of either building. But he also said, and this was my respondent's notice point, that he didn't think that the section 2.1 and 2.2 test was concerned with the boundary feature at all. And that's what you get from paragraph 36. So at 36, Mr. Justice Henry Carr said that the party wall is a boundary feature which divides the house from 1A Grosvenor Gardens. Section 2.1 and 2.2 are not concerned with the ownership of boundary features. And then I do accept that as you go on through this, he does start to look at things which I can't say are directly relevant, because he says the section is entitled meaning of house and house of premises and adjustment of boundary. And he then talks about sections 2.4 and 2.5, which again don't apply. But in my submission, there is force in the basic proposition that what section 2 is about, which is trying to identify whether a part of the building has been vertically divided, and what the current section is about, they're about the same thing. You're attempting to identify the slice. You're not interested in who owns the boundary feature, which means you're not interested in whether it's a party wall astride the boundary line, or whether it's a wall which is entirely on one side of the line, but which somebody in the past has built off. None of these things should detain the court, in my respectful submission. What you should be doing, rather than having to go through the mental process of drawing a notional line through the middle of the party wall, you don't even need to do that. You simply say, is there a vertical wall, effectively, which creates a vertical slice of the building? That satisfies the vertical division test, and there it stops. If one goes back to paragraph 25, here's more of the same point. At that point, Mr. Justice Henry Carr said, this is not a case where there is in reality a kink or dogleg which would engage section 2.2, i.e. a kink or dogleg from the vertical. On the contrary, there's a single vertical wall, a part of which divides the house from 1A Grosvenor Gardens. The fact that the dividing part is in accordance with the lease as a party wall makes no difference to this physical reality. And again, physicalness of the test is something which we know applies in the current context, because that's what Evelyn Rhodes says. And then at the end of the paragraph, in the present case, the wall as a whole creates the dividing feature, and there is no deviation from the vertical plane. I do not consider this as a mixed case, which section 2.2 is intended to cover, which is the material overlap point. And then at paragraph 26, he said he agreed with the judge that even if you regard the thickness of a single brick, and he said, if which is unclear, the party wall is in fact 2 bricks thick, above or below the level of the house, as an overhang or underhang, it's de minimis. And again, that proposition would apply to arguments about whether the footing of a foundation sticks out here or there. They're all de minimis arguments within the boundary feature.
I'm just trying to think through how this works with the foundations, if this is the right approach, because essentially you've relied on 2 approaches. One is the midpoint in the party wall, if you like, which I think is how the UT looked at it.
It is, yes.
Which you then just carry on down through the foundation.
Yes. the notional line.
On this one, on this approach, you don't go through that sort of exercise. You just say, well, the wall is the dividing feature,
Yes.
and it goes down through the house. Here, the dividing features are two-party walls, in your case. What then happens once you get to the foundations? How does it work there?
Well, look, the foundation is just a thicker part of the party wall. So that the party wall, let's assume it's 2 bricks thick as it goes down into the ground, and then in Victorian style it becomes 3 bricks thick and 4 bricks thick and 5 bricks thick to form a pad. Well, yes, those are sort of short, if you like, but they're just thicker party structures. I mean, a party wall could be, in principle, very, very, very thick. And then this is the point, it becomes a sort of so what point. You're just looking for the dividing feature and asking whether that dividing feature creates a vertical slice of the building. And in my submission, it does.
So at that point, on this kind of analysis, there'd be a bit of the, rather than there being a bit of the foundation outside the line, as it were, actually what you'd have is a sort of incursion into your side of the
I would say
wall.
if
you think of the inside of the wall as being the line.
I would simply say you don't have the difference is you just don't have a line at all.
Yeah.
You're just saying, is there a dividing feature which is a vertical dividing feature? Yes, there's a party wall, and the fact it's fatter, if you like, where there's foundations is irrelevant. I mean, a party wall might be thicker where there's a chimney flue. So what? I mean, that's not, again, that's a sort of one brick. You can't sort of go along the face and say, oh, there's a flue here, so here it sticks out a bit. And you just, I would say, rather than trying to do, maybe it's a distinction which doesn't really lead to much of a difference, but rather than bothering to say, I'm drawing a notional line right down through the middle of the wall, therefore it's vertical, you simply say, I found a wall, the wall is the vertical division, and that's effectively the end of the inquiry. So that's the sort of the respondent's notice point based on virtually, because it means you just don't have to concern yourself as a person applying the test. You don't worry about whether it's a party wall, you don't need to know how thick it is, you don't need to concern yourself with whether your notional line is in the middle or not. It goes back to Lady Justice Smith's point about whether or not she's right that a division is a line of no thickness. She is right that the test is not looking at the dividing feature. The test is looking at what is divided by the feature. There are 2 ways of getting to the same end, because, as Mrs. Justice Henry Carr said, he would have said that if the 1 brick overlap at the top is a deviation, then it's a de minimis one. So if the foundation sticks out in some way, then it is also a de minimis thing. And the same would apply to small projections you get, guttering, whatever. I mean, they're just de minimis deviations from a vertical plane, if they're deviations at all. So that was the only reason for including really section 2 of the 1967 Act, because I otherwise accept my learned friend's point that it is a grandparent, clearly, of the current test, but in many respects it does differ. But on this point about vertical division, I would say that it is very clearly the origin of the concept that you're looking for a vertical division of a building when you're looking to find self-contained premises. And it's unsurprising, I would suggest, that the draftsman, when drawing the 1993 Act from scratch, well, what would you have looked at for inspiration? It's a logical thing to have done, to have looked at the previous Enfranchisement Act, or the 67 Act, particularly because in the Malikshad case, the House of Lords said, well, clearly whoever drafted the definition of a flat was trying to capture anything which wasn't a house, as defined by the 67 Act. So the flat is the horizontal division of the building, and the 67 Act gives you a house, which is the vertical division of the building. So there is clearly this statutory lineage in a respectful submission. I don't think I need to deal with the other two respondents' notice grounds, which I did say were just out of an abundance of caution. As to...
These are really technical points, and I think it's common ground.
Yes.
Yeah, so that's how I understood the submissions this morning. Yeah.
Yes.
Just coming back, I may have misunderstood, but I want to be absolutely clear, at least for my own benefit, if you don't mind, on the foundations point again. You certainly the way I heard Mr. Bates's submission before lunch this morning was that he does, I think, place some significance on whether the foundations are to be regarded as part of the relevant building, and he says that they clearly are part of the building, so you can't just ignore them. And if as a matter of fact, let's say a case is such that the foundations are common to the larger building, then in that situation it might matter, might it, whether you have this notional line which is able to pierce down through the foundations as well.
I would say it is, if you've got, your starting point is that the building has to be structurally attached.
Yes.
Otherwise we're not there.
Yeah.
And we know that the most obvious candidate is terraced properties.
Yeah. With
the common spine wall between them. I take it on the chin. It's inevitable that if there's a shared party wall, there's going to be a party foundation. There's bound to be a shared structure beneath the shared wall. And the whether it constitutes part of the vertical slice, well, either you concentrate, which is the alternative respondent's notice point, you concentrate on identifying the vertical dividing features and then working out whether what is between them is simply what you would call a vertical division of the building. Or you draw the notional line through the middle of these party features, in which case you carry on through the foundations. And either way, the foundations, which you would call shared, yes, of course there are shared foundations, but neither of them prevents the property from satisfying the vertical division test, nor from the independent redevelopment test.
No, I understand that it on your submission it makes no difference to the ultimate answer, but it just speaking for myself, it may make a difference to how one gets to that answer, and that it may be important to say that there is, at least notionally, a vertical line. Whereas I think a few minutes ago you were suggesting that it doesn't matter, you don't have to go through that analysis, and all you need to be concerned about is that there is the physical wall.
Yes, that's my alternative.
Yes,
and it's the alternative submission which was made, which I made actually in the virtually case, which is the section 2, and by analogy section 72. I'm not concerned with that structure. They're two completely different ways. It's simply a respondent's notice point, because my primary position is that the Upper Tribunal was right in all respects.
Yes.
What the Upper Tribunal did was draw the notional vertical line. But where I think I do depart, because I understood the learned friend before lunch to accept that you can draw the vertical line through the wall.
Yes.
But then, however, I'm not quite sure how he gets there, but he didn't seem to accept that you could simply sever the foundations as well.
No.
And if you can go down through the wall, you must be able to go down through the foundations, in which case you have your vertical line, no matter how far the foundations stick out on either side. It doesn't matter.
That's helpful. I think I now am clear in my mind, at least, what each side is submitting on this issue.
I think, just following on from that, if I may, I think, as I understood the submission, it was that in reality, the foundation is actually part of number 14, including the bit which is on the other side of the notional line,
Well,
because that's how the last redevelopment took place.
that's just work on a party structure. I mean, that's, you know, again, maybe your lordship made the point. You can do work on a party structure, and party structure is the obvious way to do it. You can do work on a party structure, and that will involve exercising rights, which will then mean that there is something which the other side can use. I mean, if you get permission to build on a line of junction, for example, under the Party Wall Act, the neighbour in certain circumstances can insist effectively that they gain the right to build off the wall that you've built on the line of junction, but they then have to pay you retrospectively half of what it cost you to build the wall. This, in a sense, goes back to this is exactly where the Act isn't going. This kind of inquiry into the party structure and so on shouldn't, in my respectful submission, form part of the Section 72 test. It's allied to the point I made before lunch that in freehold conveyancing, houses are bought and sold all the time without people poring over the deeds to work out who owns this spine wall or that spine wall and who.
Well, that may be right, but I'm afraid that courts often find themselves having to deal with boundary disputes. They may not have featured when they were purchasing the land, but afterwards, neighbours often fall out with each other.
They do sometimes, but the reason why we have the general boundaries rule is because there was a period with the first Land Registration Act, I think between 1870 and 1880 or something, there was a point when you actually had to have an absolutely certain boundary, and it was a complete disaster because every single time a property was sold, then somebody was saying, oh, hang on a minute, have you got 3 inches of garden? And it basically created a dispute where there would have been none. And an echo of that is present in the approach of the appellants in this case, because what the direction of travel where the Learned Friends submission would inevitably lead is to this minute poring over things like how thick is the wall, how wide do the foundations go, do they project on one side of the wall, do they not project, is the wall on the line of junction, is it not? And these are answers which the RTM company will almost always be unable to provide because the tenants don't have the rights for intrusive investigation, etc. And they won't have as-built drawings. So it will emasculate the Act. And this is a slightly loose submission, I accept. But as a matter of very broad principle, the test ought not, and in my submission it would fail the practicality objective if one had to go into this close examination of this kind of point. I mean, it may be that the Upper Tribunal and the Upper Tribunal's answer is the simple one, which is you simply draw a line down through it and the problem is gone, because the foundations which are on the other party's side of the line are their foundations. And so that would deal with independent, whether it's a vertical division. When it comes to redevelopment, my learned friend would say, well, they had to underpin to redevelop. But I suppose the question might be is, well, what's the test for redevelopment? I mean, that's borrowing from what happened. I mean, it may be that you underpin the party wall, maybe you don't.
But that's already happened.
That's already happened.
There is underpinning.
Yeah. So
do you need more underpinning now?
Well, indeed. So that it doesn't fail the capable of being redeveloped independently test. I mean, I wouldn't want to put it on a narrow back, but you could argue that because it's already been redeveloped, at the point at which the RTM claim is made, it clearly is capable of further independent redevelopment because all the underpinning is done and it's all lovely and strong.
Well, the tribunal has to look at it as it is now, or at the time of the hearing.
Yes.
That would be. The other point might be, well, Lord Justice Lewison has told us that this is to do with the physical structure of the property and not ownership. And some of the arguments seem to get close to saying, well, in some way the foundations might belong to number 14, and it's not really clear to me how it would work.
No, it's ownership.
But it's Lord Justice Lewison has said this is a purely physical question.
Yeah, so on the purely physical basis, there's a party wall, it's got underpinned foundations or not underpinned, it really doesn't matter. Line through the foundations, you've got the vertical division. And any deviations would be de minimis, and airspace projection, they're all de minimis. And when it comes to whether or not you can redevelop it independently of the rest of the building, the question in respect, let's assume it's not underpinned. The question would have to be, does the fact that you would want to underpin the party wall, which you might in practice have the right to do because of the Party Wall Act, does that mean that you are redeveloping independently or not? And I would submit that that's actually the touchstone of independent redevelopment. If you couldn't underpin, you'd have to demolish the next door building, and that's when you fail the test. But if you can simply underpin it in the normal way that people underpin from their own property, you go in, you underpin it, I would say that that is still redeveloping independently of the rest of the building, because the rest of the building, the house next door, stands while you do the job. And if you take it, I mean, it sounds almost simplistic, but this is what the FTT said, don't overcomplicate, it's really quite simple. And does the other building stand up while you do the job? And on the facts of this case, I mean, the only suggestion that the other building wouldn't stand up presupposes that you can't prop. And in context, you're bound to be able to prop. I mean, the test wouldn't work. Whenever you do redevelopment independently of another building, you may have to prop temporarily while you do it. The other side of the line, if you have to do something permanent, and I took the example of the artificially divided building where you've got beams spanning and where you would probably have to create new structures of support in the other building to keep it up. As soon as you start saying, well, that's the kind of thing you've got to do and it's not simply temporary support, then that's different. But if all you're doing is what happened in this case in practice, then in my submission, that's capable of being redeveloped independently. The reason I've gone backwards a step and said, what if it's not already been underpinned, is because I would assume that the court would wish to give a decision which deals with a great number of properties, which sort of sets the principle. Because on the facts of this case, it's very easy for me to say, forget what might have happened in the past. It's now been done at the date of the RTM claim, which is the relevant date. It's already been underpinned, so all of this problem goes away.
Well, for my own part, I think we should decide cases on the evidence and the facts, including in this court, but that's
Yes. So,
Well, on those,
rather than giving, it's not really our job to give
we can't
general guidance about other cases.
And courts are not legislators. We don't decide other cases which are not before us.
No, I appreciate those two points indeed, and well, if on that basis, I mean, it's very hard to see how the appeal gets anywhere near getting off the ground on this, because the necessary underpinning and so on has all already been done by the date of the RTM claim notice. So this is the strongest conceivable case for saying that 14 Park Crescent at that date could be redeveloped independently of the rest of the building. Unless there's anything further with which I can assist you, I think I would probably simply be reading paragraphs out of my skeleton argument.
Any questions? Thank you very much. Yes, Mr. Bates.
A few points in reply, if I may. My learned friend doesn't place very much weight at all on the importance of the vertical division test and the identifying the purpose of this line that needs to be drawn. But in my submission, this is where he's gone quite badly wrong. The vertical line is critical not just for the operation of the test, but because it tells you what the edge of the premises over which the claim extends. And you need to know what the edge of the premises over which the claim extends, because section 96 only gives the RTM company the management functions relating to that premises. So we can't do this in this fluffy, soft edge way that might work for conveyancing. We have to know precisely what is the edge of the premises that the right is being claimed over, because the rights that are going to be acquired stop at that edge. That's why the vertical division is so important. It's why, coming back to a point I made this morning, it's why there's a real difficulty reading section 393 Act cases across. Because in section 3 cases, man for when you buy your property, you do it all by title reference numbers. Because nothing's changing hand, apart from some functions under leases being transferred, you've got to have that certainty in a way you don't have to have with conveyancing. And test it this way then. We've done our vertical line. It's gone through the middle of the premises, which is the Upper Tribunal's preferred approach and my own friend's preferred approach. The management functions include the repair of the premises. So they're going to repair half a foundation. That's the consequence of this conclusion. All of this shows you, when you step back and look at what Lord Briggs was saying in Settler's Court, all of this shows you this is not premises to which the right to manage applies. My own friend also introduced orally the de minimis points on the vertical division, both before lunch and again when discussing virtually. It seems to me that if he's going to make that submission, there'd probably have to be remission for determination, because that didn't form part of the FTT or the Upper Tribunal's decision. They haven't said these foundation bits are de minimis, nor have they said anything else that I was complaining about in the FTT is de minimis. I'm picking up on my Lord Justice Singh's point. That is quite a stretch for an appellate court on second appeal to come to its own conclusion on that. That would strike me as a remission point. It's not a respondent's notice point. I'm not going to stand on ceremony for that. It would be the simplest respondent's notice to prepare now. But it seems to me it would require remission, and there would conceivably be cost consequences for that. Independent redevelopment. My learned friend twice made his jury point about the redevelopment of the redevelopment has previously taken place. And I think my Lord Justice Mail was attracted to this at one stage as well. Can I just be something of caution on that as well? Remember, as one trawls through the expert evidence, my client had the head lease of the entirety of the terrace. So there was no question of having to talk to neighbours and make arrangements for access, etc. The whole terrace was ours under our head lease, and we could make whatever arrangements we wanted for the redevelopment. That's not the hypothesis on which the RTM operates. The RTM operates on the assumption that what you're doing is carving out against a situation where others will be outside of your control. And presumably, that's why my learned friend's predecessors didn't argue the case that way in the FTC or the Upper Tribunal, because it's not comparing like with like. On Settler's Court, I heard what the court put to my learned friend about how one could interpret what Lord Briggs had said. I just remind the court of the passages in Evelyn Road that I took the court to, where I say Lord Justice Lewison has already looked at this and has read those passages in the way that I say they should be read. A very short point on the Building Safety Act. If we can just go in the authorities bundle to 576. And again, it's the danger of taking different acts, even if they look superficially similar, and applying them to our legislation. I drew your attention at 576 to subsections 4 and 5, which I accept are similar. But note that before you get to 4 and 5, you've still got to be a relevant building, which is in 1172. So you've got to be at least 11 metres high or have at least 5 stories. That's because although 117, 4 and 5 is similar to the enfranchisement and RTM legislation, it's not dealing with terraces at all. It's dealing with tower blocks, because that's the context of the building safety crisis that we have. So again, I just repeat what I said this morning about the caution of applying different legislation. And then finally, my own friend, I think, preempted this criticism I wanted to make. Mr. Rainey gave examples of what buildings would be disqualified under his test. And he gave the example of the building artificially divided by stud walls, and then some other quite unusual cases. Tellingly, he described them as exceptional circumstances, and that shows the gloss he's putting on the test. Parliament surely intended by this test to include more than just exceptional buildings. If it wanted to only exclude exceptional buildings, you'd have had a different form of words. Ultimately, what this comes down to is that this is a claim to acquire the right to manage over premises which, as described, would see part of the foundations outside the scope of the area to be managed. It is inconceivable Parliament intended that to be the result, when we know from Settlers Court, from Evelyn Road, that this is a statutory scheme designed to create that inward-looking right.
Why do you say that that's an inconceivable outcome? I'm not sure I follow that. Supposing that you're right, and that it would mean that you'd have two people or two entities, both responsible, for example, for the repair of common foundations. Why is that any different from a party wall case?
Because it's about what you're changing from to. You're changing from a scenario where, on the facts of this case, the entire terrace is in common ownership. One entity will repair all of these foundations. We're now creating a scenario where two entities are responsible for different parts of the same foundation.
But why is it different from a party wall?
Because in the party wall, you've already got the two different ownerships. You've already got two parties who are different, and so they need to work out how to deal with that shared structure.
But it's not about ownership. This is a point about an RTM.
And it's about what they're changing from to. So this is what you get from the Settlers Court case. You're changing the situation as to how the management functions are discharged. You're changing it from a landlord operating under the scheme of leases to an RTM company operating under a statutory scheme instead. We know that shared management is to be discouraged because that's what Settlers Court says. How can it be right, therefore, to interpret Section 72 in such a way as to introduce shared management where that didn't exist before? Because that's the conclusion here.
It does exist before, potentially. It just happens on this case that there's common ownership of the whole building. But it could easily be a case where there are separate head leases, say, of each of the properties in the terrace. It's not. This case might indeed be rather unusual, but it doesn't matter because this isn't about ownership. It's about the physical properties of the property. And I go back to the point, party walls are, in a sense, a matter of shared responsibility. And if the RTM has responsibility for one side of the party wall and someone else has responsibility for the other, the Act doesn't seem to see any difficulty in that. And I can't understand at the moment why foundations are so radically different from walls.
So the foundations are so radically different in this case because of the fact they extend under the other property. That's the critical point about them.
But aren't all foundations going to do that? I mean, where could you have a party wall where the foundation stops halfway?
My lord, Evelyn Road is an example of that. Evelyn Road, terrace building, it was common ground that each of the possible configurations complied with Section 72(3). So the whole...
But that was a case, sorry to cut across you, but that was a case where the question was whether, because you could have a smaller unit, there couldn't be an RTM over the larger unit, as I understand it.
Yes.
It's not dealing with the situation we're dealing with, which is what happens at a party wall where the foundation, not surprisingly, extends under, let us say that it goes under the whole of the party wall and no further.
I think there's 2 points. I think my lord's question assumes that the shared foundations will be very common, and I don't accept that because they didn't exist in Evelyn Road. No one took that as an objection.
Do you infer they didn't exist simply because no one took it as an objection?
I do infer it from that point.
Not
Yes.
discussed, is it?
But then the second answer is this. The second answer is still Evelyn Road. Then you have to look for a configuration that doesn't have that property, that doesn't have that problem.
But aren't you going to have it in? I mean, I'm not sure whether we really need expert evidence about this, but I would have thought that it stands to reason that walls in houses, in terraced houses, which are load-bearing walls, party walls, have foundations going under the whole wall. It would be very surprising to me to think that the foundation stopped halfway.
Well, again, evidence in this case made me think quite surprising because, of course, they had to add those additional foundations going under. I can't recall anything in the expert report to suggest that the scenario my lord described is what existed here. But respectfully, the answer doesn't turn particularly on the foundations of this building. It's about what Section 72 means.
But we have to give it a sensible and workable and practicable interpretation. And at the moment, I'm struggling to see why, on your argument, virtually every terraced house wouldn't be excluded.
But we also have to give it an interpretation which gives effect to what we've been told the policy of it is. And the policy of it is explained by Lord Briggs in Settlers Court. It is not the policy of the 1993 because the context is different. Because you don't have the transfer of the freehold function, the freehold rights. There may be, if the court were with me, it may be that buildings that people previously thought could be RTM'd can't be. But this court has previously suggested that, previously held, that you can have RTMs over more than one company, and that plotted along for a few years before more than one building. That potted along for a few years before this court said that was wrong. This court had previously said you could have sharing of the communal parts. That potted along for a few years before the Supreme Court said it was wrong. If the point of this test is to identify things which can be existed without, as Lord Justice Foxton put it, the quality of management affecting other parties, then how can it be right that when you do your earth to sky division, part of the foundations that were inserted to keep your building up are on the wrong side of the line?
The difficulty I'm having, and I'm sure it's my fault, is really going back to my Lord's question to you a couple of minutes ago, is why conceptually is that different from the normal party wall situation? Because, please correct me if I'm wrong, but I think you accept that you can in principle have a notional vertical line which goes down through the middle of a party wall. Now, as my Lord has said, in a typical party wall scenario, you're going to have people on either side of the wall, therefore, probably different ownership. Let's assume there is different ownership, and therefore different people with the relevant obligations. So, and we all know, as you've reminded us, that it doesn't depend on ownership because it's a physical test. So why isn't the problem that you're identifying in the foundation context also a problem in the party wall context?
Because it's no abuse of language to describe that's cut down the party wall as creating two separate premises, which is what we're looking for here.
Yes.
But it is with the foundations. They're not the same.
Because
the foundations are integral to holding up that party wall. They're not just demarcating the divide between two properties.
But if you can have a notional line through the party wall, going down like this, when it gets to the foundation, why can't, because it's notional and not real, why can't you just carry on through the foundation?
Because it's a notional line that creates a premises to which the Act applies. Yeah. So you do your notional line, you've left part of the foundations on the other side. That is not a premises that you've created. You've chopped off part of the premises by creating your line. You don't have that problem in a wall, because a wall lends itself to that. A wall, you can see the difference between two identifiable premises, but the foundations are different because you can't say that part of my foundations under some are not part of my premises. It keeps coming back to what we need to find in section 72. We are looking for premises. So you draw your line, as the then President of the Lands Tribunal says in the Solitaire case. You draw your line. What is left on the, after having drawn that line, is what you have created premises. And if you've left part of the, in Finland Street, if you've left two parking spaces and a roller shutter on one side, it can't be said to be premises. If you've left the foundations on the other side, it can't be said to be premises. It's because of the importance of the word premises. That's what you have to create.
Thank you.
I was thinking.
Sorry, there is another question I'd like to ask. Sorry. Earlier on, you suggested that the essential question is whether the other people would be affected, and you relied on the settlers' court and so on. And we won't go back over exactly what that means. But in relation to the redevelopment bit of it, if all of the propping up and support and so on can go on inside the relevant claimed premises, here, number 14, Park Crescent, why is anyone else affected at all? Because I think one of your arguments has been it's not independent redevelopment because it requires somehow the support or consent of somebody else. But I'm just wondering what support or consent is required if all of the propping up goes on inside number 14.
If all of the work goes on inside, then that might be independent. I think I'd have to accept that.
And was there any evidence that propping up would have to go on other than inside in this case, when the experts were cross-examined and so on?
Not that I don't recall anyone cross-examining on this. It was some years ago now, so forgive me if I rack my memory. My recollection, for what it is worth, is that there was very little exploration of this because the entirety of the terrace was in my client's control at the time. And my recollection, I think if you look at the expert reports, they explain all this. Although it's phased, not built, not number 14, then number 12. I think when we look at the dates, parts of number 12 are still going on when number 14 is being built, etc.
I thought 12 was already occupied at the time of the redevelopment.
They were doing some work to the roof of 12 when 14 was still going on. I looked at the report, expert again over lunch.
Okay, thank you very much.
Any other questions?
Thank you.
Thank you very much. Now, may I just check, are you intending to stay for the hearing of the other appeal? Because you're welcome to.
I certainly was, yes.
Yep, that's fine. And I assume we're going to have some physical reconfiguration of the courtroom. And can I just check with counsel in the other appeal? I assume you're content to begin this afternoon?
Yes, if you wish, you can do that.
Yes, I think that would be sensible given the time that's left in the court day. Would you like a couple of minutes while we rise so you can reconfigure?
Yes, please.
Very good. We'll just be outside.
Is a good example.
That's really good. See if I can get some kids.
What ready to resume? Court rise if able.
Yes, Mr. Jacob.
Yes, my lords. The appeal that we're now concerned with is really three appeals because it concerns three separate right to manage companies, all of which sought to acquire the right to manage their block within the development in Liverpool. In each of the three cases, the First-Tier Tribunal determined that they were not entitled to acquire the right to manage because they failed the vertical division test in section 72(3)(a). And the Upper Tribunal accepted that, although for different reasons, those put forward by the First Tribunal. And the point by the Upper Tribunal found against us on was as to whether one can have a notional vertical division passing through air within a building, or whether one has to have a physical structure. The Upper Tribunal gave permission to appeal on that issue of the correct interpretation of vertical division. In respect of the respondents, there are two respondents. So there's a respondent, the second respondent, represented by my own friends. That is the landlord in respect of only one of the three blocks, the terrace. And in the respondent's notice, the second respondent raises other issues in respect of vertical division with which the Upper Tribunal was not with them, and also questions the interpretation the Upper Tribunal put on independent redevelopment. So those issues are raised in the respondent's notice. That's in respect of the terrace, but in respect of the courtyards and the studios right to manage claims, the respondent has not participated in this appeal and is not represented today. So my submission in respect of the terrace appeal you are concerned with various issues, those raised by the appeal and by the respondent's notice. But in respect of the appeal for the two right to manage claims by the Courtyard RTM company and the Studios RTM company, the only issue that's before you in my submission is the issue of whether one can have a notional vertical division through space within a building. And the other issues that my learned friends seek to rely on, they do not arise in that appeal. So if you're with me on the issue of one having a notional division through airspace within the built structure of a building, then the appeal can succeed in respect to the Courtyard and the Studios, and you don't need to go on to consider whether they can be independently redeveloped, because that hasn't been raised by way of a challenge by the respondent to those appeals. In respect to the facts, we're dealing with a very different type of premises from the previous case. This is a modern development, newly built between 2008 and 2018. There's a description of it in the agreed statement of facts and issues from the Upper Tribunal, which you have in the supplementary bundle, and you will also see in the Upper Tribunal judgment there's a quite detailed explanation about the premises. I don't propose to take you to that now, but I thought it might be helpful to have a look at some photographs to get an understanding of how this all works. So, within the supplementary bundle, we go to page 85, just to start with. So on page 85, you should see an overhead, I think taken from Google, photograph above the development.
Yes.
And it shows us all of the 5 blocks. There's a word of caution in respect of this. In respect of the bottom left block, that's a sort of slightly circular slate, but not quite. There's a pin saying X1 the Studios on top of the roof of that. That is a little misleading. That is not the Studios. That is what is known as the tower. The Studios is the rectangular block towards the left of the page, halfway up the page. To the right of the Studios, the L-shaped block is called the gallery. So that's one that's not subject to any right to manage claim. To the right of that is a block in a strange shape. It's called the Courtyard. It has a pin above the roof of it. That is one of the right to manage claims. And to the bottom right, you'll see the terrace, which is the one which raises the respondent's notice point. In the middle of that, we have a road, Plaza Boulevard, which you can see coming off a road to the right, Stanhope Street. It goes between the Courtyard and the terrace. And then there is an entrance. One can see on Plaza Boulevard, there's a sort of hatched yellow area. There's a turning off to the right there. That is a turning into what's called the gallery. There's an entrance there, and that takes one down into an underground car park, which spans between all of these blocks. And so the underground car park will go under the whole of Plaza Boulevard, and it goes under, to some degree or another, each of the 3 blocks over which the right to manage is claimed in this case.
Yes.
The way in which the development was built was in stages. So the gallery was built first with part of the car park and also a suspended road deck. So the road that we see Plaza Boulevard was suspended above one roof height above the basement of the car park. After that, the next 3 phases were the 3 blocks that we're concerned with. So the Courtyard was second phase, then the Studios, then the terrace, and finally at the end of it all, the tower was built. Once all this is built, we have a number of steel structures, we have a suspended road deck, and then without more, there would be gaps between Plaza Boulevard, the suspended road deck, and for instance, the terrace property. But there you can see something has been inserted between that, a sort of brown colour. This is a podium infill, which has been inserted to bridge the gap between the suspended road deck and the terrace. And there's also such infill with the Studios and the Courtyard. So all of them have this structure covering the roof of the car park between each steel structure block and the suspended road deck. And on the suspended road deck, there's a downstand beam, a concrete downstand beam, and the podium infill latches onto that and then goes across to each of the steel structures.
So the podium is at the level of that bit of road, is it?
Yes.
It's flat, as it were, with the
Yes.
with the road.
Yes. So if one goes to this development, if one was walking on Stanhope Street to the right of the page and walked into Plaza Boulevard, one would, from that perspective, be at ground floor level, walking along a road. To the right and left of the road, one would see the ground just continues beyond the road up to the doors of the various premises. And one would not necessarily understand that one was walking above a car park below that whole structure.
And that level, sorry to just try and understand, that level is what's called the podium.
Yes. So, yes, podium, we say podium infill is one way of describing it, to fill in the gap between the suspended road deck and each of the blocks. The podium level is inserted, fills in the gap, creates what one perceives from ground floor level as just, that is the ground. The car park entrance I referred to in the gallery, that can be seen on the next page, page 86. So one goes into that, down a ramp into a car park basement below. You may have seen reference, if you managed to read through some of the experts' reports, to different levels. So the development is on an incline. So for instance, going to the previous page, Sefton Street at the bottom of the page is at the bottom of the incline. From there, the development gradually goes uphill. And so, for instance, I think the car park level of the terrace will be below the car park level of the studios. But each block only has one level of car park underneath it. It's just that there will be an incline within the central area of the car park to take you up from one lower level of the terrace to a higher level of the studios, because the studios are simply built higher than the terraces because of the incline.
Is it possible to drive a car from one end of the car park to the other, even though you're going up an incline?
Yes, you drive up an incline, the car park, a roadway within the car park.
So it's a ramp or something?
Yes. Some
Between
kind of ramp.
essentially between two levels within
Yes.
the car park.
Yes, that's as I recall from the site visit. That's my recollection. Within this, as you don't have the benefit of the site visit, you do have the benefit of some photographs that we provided the Upper Tribunal, because again, the Deputy President of the Upper Tribunal didn't have a site visit. They're all focused on the terrace because we've generally just focused on the terrace, so we don't have much by way of photographs of the other two premises. But as regards vertical division and this issue of whether you can have a notional line through space in the building or not, you don't really need to go beyond the pictures you can see of how it is in the terrace to understand the effect of that on the other premises that are claimed as well. If we go to page 84, you can see the terrace. So this is taken from part of some report. I think we just have a few extracts to give you some photographs to show you what this looks like. So here with the terrace, we're on Sefton Street at the very bottom of the incline, looking at the terrace. One can see to the left of this building, there's a staircase going up. That staircase is between the terrace and the tower. So to the left of that staircase, this other structure, you can see that's the tower. This staircase is attached to the terrace steel frame, and that's a point which my learned friend makes as to independent redevelopment. He queries whether one can do an independent redevelopment given that this staircase is bolted on, and if one removed the premises, then the staircase might collapse, subject to propping arguments, which we can come to. If we go to just bear with me 1 second.
Just when we're on that picture, sorry, just is the bit of sort of overhang at the top, is that what's called the parapet?
Yes, that is. It's the wrong side of the argument, but yes, it's the argument relates to the other side of the premises, but that is part of the parapet. If we go to page 79, there's a slightly better quality photo of what we're looking at here with the terrace. And again, yes, you can see the parapet coming off the top there. There are also some balconies jutting out on this side. That was challenged as a problem with vertical division in the First-Tier Tribunal to say that you can't have a vertical division because the balconies jut out over land nearby. But that's no longer an issue. It's now accepted that that doesn't create a problem with vertical division. And we have to only look at the other side where the premises are structurally connected to the rest of the building.
Yep.
Just bear with me, I'll find a picture of the parapet on the side that we are actually dealing with. So that's page 81 is one example. It's much smaller pictures. At the bottom of 81, those two pictures on the left is looking from Sefton Street, I've just shown you, where we're not concerned with that side. And from the right picture, the front elevation, this is looking from the Courtyard building over the suspended road deck, which is that road there, towards the terrace. And there you can see the parapet on this side goes across the whole of the building rather than in stages on the other side. So that is one of the points taken in the respondent's note, is to say you can't have a vertical division because it juts out at parapet level, and that breaks the vertical division, it said.
And the building that it's jutting out over is what's called the building is just the road level fill-in,
The podium, yes.
the podium.
So the basis upon which this is, I think, accepted, but certainly not being an issue in the Upper Tribunal and going forward, is that the whole development itself could consist of a building, a self-contained building as a whole. So you would take the 5 blocks, all of the car park, it's all structurally attached, so that satisfies the definition of a self-contained building. And that argument succeeded in the context of the 1993 Act in the Palgrave Gardens case, which I'm not sure if you've been referred to during submissions today, but it's in the bundles. So that was the case, I think it was, I can't remember whether that may have been 6 blocks, but again, an argument raised as to whether you can have the whole structure, and that succeeded there to claim the whole development in that case. So we don't have an issue here as to this all being part of a larger building. The issue is whether each of the blocks, as we sort of define them in our phone notices, can be a self-contained part of that larger building. Within the terrace, I can show your lordship some photographs showing how the car park looks when we're talking about the notional vertical line. So, well, perhaps actually I could take you some plans in the experts report first before the photographs. So if we go to page 63 of the supplementary bundle, we have some plans within an expert's report from Mr. Reed, the expert for the landlord in this case. So 63, one can see a blue shaded section here. This blue shaded section in this plan is the car park, the extent of the car park. What one can also see in faint red dashes and or faint blue dashes are the outlines of the footprint of the buildings above the blocks. So towards the bottom right, you can see the footprint of the terrace, and one can see that part of the basement area is car park and part of it relates to the rest of the built structure. To the top left, you see the studios. Again, there's a cutout where part of the basement is car park and part of it is the built structure. For the courtyard, to the top right, there's a much smaller area. So there's only a thin sliver in respect to that, but each of them has, to some extent, some car park going into the basement area. There are some photographs of sections here, section 1-1 and section 2-2, put in there to assist in understanding how this works. Unfortunately, these photographs are misleading. I think I clarified this with my own friend previously, long before this hearing, months ago, but I think we both agreed that they don't show what they purport to show. So they suggest from the plan that they're trying to show you the divide between, in the basement, between the footprint of the terrace and the car park beyond. But actually what they show you is a different section of the car park where the podium attaches to the suspended road there. That's what they show you. They're not showing you the area we're most concerned with in this. So, for instance, the photograph in the top right, section 1-1 with the red car, there's a concrete column on the right-hand side with some yellow and black stripes leading up to a beam. All of that concrete, that is part of the beam that the suspended road deck is on. To the left of that, the steel beams and the serrated metal material, that is the podium being attached to the downstand beam on the road deck side of things. I think that's correct for all of these photos. These are not showing you how the podium connects to the terrace. So that's just a word of caution there when considering those photos. Over the page, there's a different version of the plan. This one shows you the blocks more clearly. This is supposed to be a ground floor plan, so the blocks themselves are more clearly set out with their various colouring. And the underground car park is harder to identify, but that's the dotted or dashed blue line outlining the extent of the car park. So moving back to photographs now, we have a set of photographs taken of the terrace, starting, perhaps I could take you to page 78 of the supplementary bundle. So this here, we can see a black steel column going up in the middle of the page. Everything to the left of that steel column is car park that's underneath the structure, the steel structure of the terrace. Everything to the right of that is underneath the podium. So the terrace itself has this steel structure made up of a row of these columns going up in steel, connected to beams going to the left in steel and other ones coming down in an X shape that one can see behind that black car. That's all part of the steel structure of the terrace that was erected there. Underneath it, we have the slab, ground-bearing slab at the bottom of the car park. To the right of this steel column, we have another steel beam that one can see going down the page away from us. That is bolted onto the frame of the terrace, and that's part of the podium structure. And so the podium has this steel beam going down away from us. It also has these various steel beams going to the right down the page, and they all go under the podium and then connect up to the suspended road deck, the downstand beam on the other side. And then they have various material above those beams, which makes the structure that becomes the ground when one's above ground level. One can see on page 77, this is a photograph looking the other way. So we're now midway down the terrace looking away from the tower towards the end of the development. And again, we can see to the right of that steel column, that's underneath the structure, to the left is underneath the podium. And as the Upper Tribunal correctly observed, there's no real difficulty in identifying the area over which the right to manage is claimed. It's simply the area of car park that's underneath the steel structure to the right of those steel columns. But nevertheless, the Upper Tribunal considered that the lack of some wall separating the entirety of that part of the car park means there can be no vertical division. This is dealt with in the Upper Tribunal's decision, paragraphs 67 to 77, under a heading of undivided spaces. There seem to be essentially 3 points that were made by the Upper Tribunal. It's not just this point about there being no physical structure, it goes beyond that in its reasoning. So I'd like to just take you to that and then seek to go through each of the elements of reasoning to say why I say they are wrong.
What page are you on now?
So if we go to the core bundle, page 39, so this is the section halfway down the page. You'll see the italicized heading, undivided spaces. And so from paragraph 67 onwards, that's where the Deputy President deals with this point. If we go over the page to page 40, after he's dealt with various submissions, paragraph 73, he comes to the first of his 3 points, it seems, in deciding against the right to manage companies. So paragraph 73 says, I don't accept Mr. Jacobs' submission. At basement level, the car park beneath the individual box is not part of self-contained premises in the ordinary sense, is open plan and undivided. So this is his point about there needing to be some physical structure, a wall or whatever, separating the part from the remainder. But he goes on to make other points at paragraph 74 to 76, drawing on the words of Lord Briggs in Settlers Court. So 74, he says, additionally, it seems to me to be unlikely to have been intended that the management of what is in practice an undivided space would be divided between the building owner and RTM company. Such division of responsibility in practical is not contemplated by the RTM regime. He then refers to paragraph 35 of Settlers Court. And there's another point on top of that. He has a point at paragraph 75 saying that the one difficulty which the RTM company would face is that others who are not tenants of the block have been granted rights, including in some cases leases of parking spaces within the area over which it claims the exclusive right to manage. And he refers to another section of the judgment of Lord Briggs. So there's actually other points beyond the mere is there a wall. He is incorporating elements of the Settlers Court to say that one cannot have right to manage because third parties have been granted rights over parking spaces in the premises and or because you'd have to share management of an undivided space. I'd like to deal first with these latter 2 points about Settlers Court and what effect that has, because in my submission, reliance on Settlers Court has been misplaced by the Upper Tribunal in this case. And the overarching reason for that in my submission is that the test for vertical vision is a physical test. And we know that because of Evelyn Road, which you've been referred to a number of times today. Paragraph 36 of that, it is at page 530 of the Authorities Bundle, states where the premises satisfy the definition of self-contained building or part of the building is a purely physical test. The definition is concerned only with the structure of the built envelope, its internal structure, and the separability of services. Within that, it considered Settlers Court. It had sections of it quoted, so it's not as if they were dealing with this without knowledge of that case. Settlers Court, in my submission, takes the same approach. If we look at the Authorities Bundle, page 516, we have paragraph 46 at the bottom. Finally, it is instructed to observe the use which is made of the phrase of pertinent property in the operative parts of this chapter, which really was most of the focus of Settlers Court was about what the pertinent property amounts to, what is the correct definition of that. In section 72.1 is used as part of a larger phrase, with or without a pertinent property, so as to make it clear, for example, that the fact that the building has an pertinent outhouse or garage does not mean that it fails the requirement that it be self-contained. Now, the section 72.1 part of the statute, by way of reminder, that says this chapter applies to premises if A, they consist of a self-contained building or part of a building, with or without a pertinent property. And then it goes on later in the section to explain what is meant by these self-contained buildings or parts. It carries on paragraph 46. This is part of an entirely physical set of qualification requirements, not directed at all to the question what easements or other incorporeal rights may serve the building. Further down, 4th line down on page 517, it starts, so if a pertinent property was meant to include, there's a sentence there, and then the next sentence, about 7 lines down, but this is plainly contemplated by section 72.1a and makes sense only on the basis of the phrase was purely about physical objects. So in my submission, Settlers Court itself made the same point, that this is a physical test we're dealing with. Court of Appeal in Evelyn Road then considered Settlers Court and restated, yes, it's a physical test, that's what we're dealing with. None of the parties to either of these appeals challenges the authority of Evelyn Road. So if we start with a physical test, the upshot in my submission is that when considering whether there's a vertical division between part of the premises and the remainder, one can't be concerned about whether the landlord has granted rights to third parties over parking spaces. The fact that any rights have been granted is nothing to do with the physical nature of the test that we're concerned with. also, it's not really related to this aspect of the test. Even if it were part of this test, why does it relate to vertical division? Imagine if we had a scenario where there was a wall all the way down the car park along the footprint of the terrace. There was complete division by way of a physical structure where there was no ability to get from one side to the other. The landlord can still grant rights to third parties over part of that basement that's in the terrace. That doesn't relate to vertical division at all. That's just something outside of the test we're concerned with in my submission. So why would it relate to vertical division any more than it would relate to independent redevelopment? It's simply not related to those questions. It's a landlord granting some rights by way of a lease or something else to a third party. It's not a physical aspect of the premises with which we're concerned.
Just suppose, for the sake of argument, that you're right on this point, and that the additional second and third reasons which the Deputy President gave at paragraphs 74 and 75 of his judgment are erroneous in law. Right? Just suppose that. Could it be said that the reason he gave at paragraph 73, which does appear to be about a physical point, would be sufficient?
Yes, I accept that he could stop there. If he's right about that, then yes, it is in itself a reason to decide against the appellants.
Right.
But given that he has inserted these additional reasons and quite a lot of weight, I think, will be placed on them by my own friends, I do invite you to expressly reject these, irrespective of how you decide the other issue. This incorporation of concepts from Settlers Court to try and shoehorn them into this physical test is not an appropriate way of interpreting this statutory provision, section 72, really, in my submission. And it needs to be clarified in this case because it is part of the reasons that the judge gave. So, going back to Settlers Court, again, just to carry on with my argument about this, one can see what the issues were if one goes to paragraph 3 of Settlers Court. So now we're on page 505 of the authorities bundle. And there it says, the appellant says the 2002 Act confers upon the RTM company an exclusive right to manage the relevant building, together with any other facilities used exclusively by tenants within that building, but no right to manage the estate facilities. The first respondent RTM company claims all those exclusive rights and also a right to share in the management of the estate facilities, together with any other person entitled or obliged to do so, with the terms of shared management and the allocation of its cost to be resolved between them by agreement. So the starting point in the first two lines is that everybody there agreed that the RTM company had an exclusive right to manage the relevant building. The only dispute was about, well, what happens if you have things outside of your building that you are trying to manage? If they are shared, can you still claim the right to manage them? So the issue that we're concerned in this case wasn't in issue in that case. They didn't have anybody arguing, well, there are some kind of rights granted to third parties within the building, and that somehow affects the acquisition of the right to manage. The Supreme Court wasn't seeking to interpret the definitions of self-contained building or part in section 72. It was really focusing on the definition of a pertinent property and whether that could be used as a way of trying to acquire rights outside your building or part. And we can see this in my submission. 3 paragraphs indicate that the Supreme Court wasn't concerned about any issues inside the building. So if we go to page 514 of the authorities bundle, paragraph 35, it's Law Briggs is considering section 79.2 related to insurance. Just above the D, halfway along, there's a sentence starting, that is a very powerful point to the construction which confines the right to manage to that which the RTM company can manage on its own, namely the structure and facilities within the building or part of it constituting relevant premises, and where there exist those facilities outside it which are exclusively used by the occupants of the relevant premises. So the Supreme Court wasn't saying there was any question about being able to manage what's inside the structure of the relevant premises of the building. They're only looking at what's outside and what is the test when you get to what's outside the building. In my submission, this is also apparent from paragraph 54 on page 519. This is a section dealing with the absurdity argument that was run by the managing company in that case. By D, the last 3 lines of paragraph 54, by contrast, a right to manage the premises which extends only to the relevant building and to the facilities exclusively used by its occupant tenants avoids all or almost all of these difficulties. So again, the right to manage the relevant building, and then it talks about the exclusivity of things outside the building. Finally, paragraph 62 on page 521. I consider the right to manage scheme in Chapter 1 of Part 2 of the 2002 Act makes no provision within the statutory right to manage for management by the RTM company of shared estate facilities. It is concerned only with management of the relevant premises, that is, the relevant building or part of the building, together with a pertinent property of any, which means nearby physical property over which the occupants of the relevant building or part have exclusive rights. So again, it's all, the arguments here are all focused on the extra bit after you've already gained the right to manage the building or part. What can you get beyond that? That's what the focus of this was about. That's what the arguments were about. In my submission, to the extent the Supreme Court did consider shared facilities inside a building, it envisaged this could be possible. And the reason I say that is when it considered section 97(2), so the provision itself is set out on page 510. So just by way of reminder, page 510, near B, it has section 97 and 2. A person who is A, landlord under lease of the whole or any part of the premises, B, party to such lease otherwise than landlord or tenant, or C, a manager appointed under Part 2 of the 1987 Act to act in relation to the premises or any premises containing or contained in the premises. And then the important bit is not entitled to do anything which the RTM company is required or empowered to do under the lease by virtue of section 96, except in accordance with an agreement made by him and the RTM company. So that envisages agreements being made for management to remain with the existing manager. And Lord Briggs came back to this on paragraph 42. So if we go to page 516, paragraph 42, the second line down on page 516, Lord Briggs is considering what the purposes of section 97(2), and he says here, and section 97(2) is by no means necessarily there for that purpose. Rather, it sensibly contemplates latitude for the RTM company to allow the landlord or third-party manager to continue to perform some management functions within the building. All the other facilities used exclusively by the tenants of the relevant building in place of the RTM company. An example might be a tenant's car park where only some of the spaces are reserved for tenants of the relevant building. It would make obvious sense for the RTM company to agree to allow the landlord or third-party manager to continue to manage the car park as a whole. So they're contemplating inside your building, you could allow the existing manager to continue because of some reason why it made obvious sense in the particular facts of the case. So the Upper Tribunal recognised that the Supreme Court was dealing with a different issue. If we go back to the core bundle, page 41, paragraph 76, in light of the submissions that I'd made, the Upper Tribunal Deputy President said, I appreciate the issue determined by the Supreme Court and Settlers Court was not concerned with the definition of the premises in the 2002 Act, but rather with the existence of, the extent to which an RTM company was entitled to manage a pertinent property as defined in section 1121. Just as a technical point of clarification, the Supreme Court was concerned with the definition of premises because the definition of premises actually includes within it a pertinent property. If one looks at section 72(1, it doesn't make much difference to the decision, but strictly speaking, that's not correct. If we go to page 26 of the core bundle, paragraph 6 at the bottom starts to set out the whole of section 72. So section 72(1) says this chapter applies to premises if, over the page, A, they consist of a self-contained building or part of a building with or without a pertinent property. So actually, the pertinent property is part of the premises if it exists. So, point of clarification, back to paragraph 76 on page 41. Settlers Court was dealing with the definition of the premises, but in my submission, it wasn't dealing with the definition of a building, a self-contained building or a self-contained part. It was dealing with the add-on of the premises, which is whether it has a pertinent property that can be acquired by the right to manage company. But in any event, again, going back to my overall submission, the Upper Tribunal in my submission failed to recognise that by trying to incorporate some of the reasoning from Settlers Court into this test, it's departing from the physical nature of the test. It's not looking at the physical circumstances anymore, it's looking at rights granted by a landlord. And this is wider. This is not just about car parks. This is about anything that could be within a self-contained building or part of a building that's physically self-contained. However, that test has to be arrived at. One could have a gym in a self-contained building, a swimming pool where some rights are granted to people from another set of premises to access that. And in fact, the reasoning of the Deputy President in these paragraphs 74 to 76 of the Courtyard is filtering into other cases. In May this year, I will be appearing in the Upper Tribunal against Ms Gibson in a case where a self-contained building, a structurally detached building, has been found to have acquired the right to manage by the First-Tier Tribunal, and permission to appeal has been given on the basis that the First-Tier Tribunal didn't take into account the fact that within that structurally detached building there was a gym, a swimming pool, a zen room, and various other things that could be used by parties outside of that building.
A zen room.
A zen room, yes. And so the argument goes that, well, given the Courtyard shows it's not just about physicality, it's about more than that, it's about rights of third parties. If you have a building or part and somebody outside of it being granted rights, it's no longer self-contained. So in my submission, this is erroneous reasoning that is now filtering out into other cases. There's also a judgment from December last year of the First-Tier Tribunal, Canary Riverside RTM and Octagon Overseas, in which I think Mr Bates and Mr Rainey both appeared. I wasn't involved, but having read the judgment, it seems that there was an argument again there by Mr Bates that Section 72 is not limited to purely physical questions. It includes whether management is self-contained, and there's again reliance on the Courtyard. So this is appearing now in cases out there. In my submission, it's all wrong. Everybody is proceeding down a wrong route because the Deputy President here has wrongly interpreted the relevance of Settlers Court to this question of whether you have a self-contained part of the building. And so my submission, you should make very clear, irrespective of the overall outcome of this appeal, that this is not the correct analysis. It simply goes against what was said in Evelyn Road about a physical test, and that should be clear in my submission.
This may be a small point, but given the time, perhaps I can finish on this one. In paragraph 77, which I understand to be a sort of concluding paragraph to this section of the judgment, certainly as I read it, the last 3 or 4 lines sets out this conclusion: I am satisfied that the presence of the undivided car park means that individually the blocks do not constitute a vertical division of the estate as a whole. That's fatal to your claims.
Yes,
I'd understood that to be the fundamental point about the absence of a physical division.
That is the largest of the points, yes, and it would be fatal. So that's my next thing to come to. But as I say, the Deputy President felt it appropriate to make these additional comments as if they were further reasons.
I understand that, and I'm not criticising you or curtailing you from making submissions about those parts of his reasoning at all. And you may be right that whatever the outcome of your appeal, that that this court should say something, depending on what view we form about the other parts of his reasoning. But I just was focusing on the fact that it does seem to have been at least the most significant part of his reasoning, that there was an absence of physical division.
That is, yes, the most significant. But the other factors that he has considered from Settlers Court and rights granted may have influenced to some extent the way that he approached the other problem, although wouldn't have been the absolute answer to it.
I understand. Now, would that be a convenient moment to pause for today?
It would, because I was going to now move on to the key points, so
Very
perhaps I can start that tomorrow.
Very good. We will resume at 10:30, and I don't want to hold anyone to this at all, but it does seem to me that we're going considerably faster than the agreed timetable had envisaged. And are you able to give me any kind of indication of how much longer you'll need?
I might be able to finish in an hour to an hour and a quarter, depending on how much questioning
All right.
I receive.
Let's see. And roughly, do you know how long you'll need, Mr. Anderson?
My lord, I think around an hour and a half. We might be possible to finish by lunch.
Yeah. Well, if we can, that's fine. If we can't, then the court is and was scheduled to sit tomorrow afternoon anyway. But it's just helpful in planning the diary for tomorrow. Unless there's anything else, we will adjourn until 10:30 tomorrow.
All rise in favour.
That really good. Yeah.
My papers.
I would have thought so, yeah.
Some people have two, as in please.
To leave stuff as well. Yeah,